Okay, we're going to read the rest of corporations, modules 7 through 10. And how are we going to do that? All right, we're going to open the document up. Let's find it. Here, we left off on page 43. Module 7 is about shareholders, management liability, and derivative suits. The power to manage the corporation generally is vested in the board of directors. Generally, the shareholders have no direct control and management of the corporation's business. They may act in their own personal interests and generally have no fiduciary duty to the corporation or their fellow shareholders. Shareholder liability is thus limited for liabilities for unpaid stock, pierced corporate veil, or the absence of the de facto corporation. I'm just looking for like a hair toy. Okay. So, closed corporations. Shareholders can run the corporation directly in a closed corporation. The characteristics of a closed corporation are that there are few shareholders and the stock is not publicly traded. In a closed corporation, we can set up management with a board of directors and run it like a regular corporation, or we can set up management differently, such as by eliminating the board and having shareholders run the business, or appointing a manager, and so on. Shareholder management agreements. Shareholder management agreements set up alternative management for a closed corporation. The MBCA allows shareholders to enter into agreements to dispense with the board and vest management power in the shareholders. If the articles do not include such a special provision, shareholders exercise only indirect control of the corporation through their voting power, by which they elect and remove directors, adopt and modify bylaws, and approve fundamental changes in the corporation's structure. There are two ways to set up a shareholder management agreement. One is in the articles or bylaws and approved by shareholders. By unanimous written shareholder agreement is the second. Either way, the agreement should be conspicuously noted in the front and back of the stock certificates. Failure to do so, though, does not affect validity. If the shareholders do to this and set up management by shareholder or by manager, who owes the dues of care to the loyalty of the corporation? It's whoever manages the corporation. Managing shareholders will thus have the liabilities that a director ordinarily would have with respect to that power. Okay. So, we made it one page. There's only 3 modules though this time. So, special fiduciary duty in closed corporations. We just saw that whoever manages the corporation owes the duties of care and loyalty to the corporation. In many states, courts impose a fiduciary duty on shareholders owed to other shareholders. Why? Because a closed corporation looks like a partnership with few owners who usually are employed by the business. Because partners owe each other a fiduciary duty of utmost good faith, these courts apply the same duty in a closed corporation. Especially controlling shareholders should not oppress minority shareholders, for example, by selling control to people who loot the corporation, meaning the controlling shareholder didn't conduct a reasonable investigation of the buyer. Duties of controlling shareholders to minority shareholders. Controlling shareholders cannot use their power to benefit at the expense of the minority shareholders. The controlling shareholders could be a corporation. For example, a parent corporation could not use its domination of a subsidiary corporation to receive something to the detriment of the subsidiary's minority shareholders. Doing so would breach its duty. There is also a duty to disclose material information to the minority shareholders. Oppression of minority shareholders. If there is oppression of minority shareholders, they can sue the controlling shareholders who oppress them for breach of this fiduciary duty. For example, the controlling shareholders might deny the minority any voice in corporate affairs, fire them from employment, refuse to declare dividends, and refuse to buy the minority stock, so the minority is getting no return on investment. Why do some courts let the minority shareholders sue here? Because oppression thwarts their legitimate goals for investing, and they have no way out because there's no market for the minority shareholder stock. Professional corporations. Most states prohibit professionals from forming corporations under the General Corporation Statute for the purpose of practicing their professions. This rule is based on the idea that professionals should not be able to avoid personal liability for their own malpractice by hiding behind the corporate veil. However, most states have adopted special statutes permitting professionals to incorporate so that they can take advantage of certain federal tax provisions that are available only to corporations. Formation and name. Licensed professionals, including lawyers, medical professionals, and CPAs, may incorporate as a professional corporation or professional association. The name must include one of those phrases, PC or PA. The articles must state that the purpose is to practice for a particular profession. Employees, directors, officers, and shareholders usually must be licensed professionals, but may the professional corporation employ non-professionals? Yes, but not to practice the profession, to render professional services. Liability. The professionals are personally liable for their malpractice. Remember, a person is always liable for their own torts. However, shareholders are generally not liable for corporate obligations or for other professional malpractice. Governing rules. Generally, the rules governing regular corporations apply to professional corporations. Can shareholders be held liable for corporate debts? Shareholders generally cannot be held liable for corporate debts. Why? Because the corporation is liable for what it does, and shareholders have limited liability. But a shareholder might be personally liable for what the corporation did if the court pierces the corporate veil. This most commonly happens in closed corporations. Piercing the corporate veil. The general standard is that courts may pierce the corporate veil to avoid fraud and unfairness, to pierce the corporation veil and hold shareholders personally liable. 1 and 2. 1, the shareholders must have abused the privilege of incorporating, and fairness must require holding them liable. Note that something like sloppy administration is generally not enough to pierce the corporate veil. Common schemes, elements justifying piercing. There are several classic scenarios in which the corporation is often pierced. Alter ego, identity of interests. If the shareholders ignore corporate formalities such that the corporation may be considered the alter ego or a mere instrumentality of the shareholders or another corporation, in some basic injustice results, the court may pierce the corporation veil. These situations may arise where shareholders treat corporate assets as their own, commingle their money with corporate money, and so on. Undercapitalization. The corporate veil may be pierced where the corporation is inadequately capitalized, so that at the time of formation there is not enough unencumbered capital to reasonably cover their prospective liabilities. Fraud, avoidance of existing obligations, or evasion of statutory provisions. A corporate veil may be pierced where necessary to prevent fraud or to prevent the individual shareholder from using the entity to avoid his existing personal obligations, but the mere fact that an individual chooses and adopts a corporate form of business to avoid future personal liability is not itself a reason to pierce the corporate veil. Who is liable? Normally, only shareholders who are active in the operation of the business will be personally liable. Liability is joint and several. Remember, piercing the corporate veil allows imposition of liability on shareholders for what should be a corporate debt. That shareholder might be another corporation. For example, a parent corporation could form a subsidiary to avoid its own obligations. The court may pierce the corporate veil to hold the parent corporation liable and go after the parent corporation's assets. On page 50 is a chart of personal liability of shareholders for corporate obligations. It's a decision flow chart. So the first inquiry, is there a du jour corporation, i.e. have all statutory formalities been met? If yes, can the corporate veil be pierced because of 1, 2, and 3? Corporate formalities have been ignored and injustice has resulted. The corporation was inadequately capitalized, or it is necessary to prevent fraud. The answer is yes, the shareholder can be held personally liable for corporate obligations. The answer is no, the shareholder cannot be held personally liable for corporate obligations. So, de facto corporation doctrine is what exactly? Or it's kind of cut off here by my screen. What is it? Sorry, is the de facto. So the other side of the decision tree, when you answered no, if you have a de jure corporation, the next question is this: is the de facto corporation doctrine available, colorable? Assuming there was a colorable good faith compliance with most statutory requirements, note that the shareholder must not have known of a lack of incorporation. If not, is there a corporation by estoppel? And i.e. in a contractual situation, and have the parties act as if there was a corporation. If yes, the shareholder cannot be held personally liable for corporate obligations. If no, the shareholder can be held personally liable for corporate obligations. There's a star. Most courts will hold only active shareholders liable. The shareholder whose only connection to the business entity as an investor generally will not be held liable. So the types of liability, we're going to go into the corporate veil. Easily pierced in tort cases, not so much in contract cases, since parties who contracted with the corporation had an opportunity to investigate its stability. In other words, unlike a contract claimant, the tort victim did not voluntarily choose to transact with the corporation and did not knowingly assume the risk of limited liability. Where the corporation is insolvent, claims of shareholder creditors may be subordinated to outside creditor claims if equity so requires, for example, because of fraud. Who may pierce? Generally, creditors may be allowed to pierce the corporate veil. Courts almost never pierce the veil at the request of a shareholder. Shareholder as plaintiff and recovery. In a derivative suit, the shareholder is suing to enforce the corporation's claim, not their own personal claim. In other words, if a shareholder believes the corporation has been wronged, but the directors have done nothing to enforce its rights with respect to the wrong, the shareholder may be able to bring a shareholder derivative suit to enforce the corporation's rights. It's a case in which the corporation is not pursuing its own claims, so a shareholder steps in to prosecute for the corporation. You should always ask, could the corporation have brought this suit? If so, it's probably a derivative suit. Compare direct actions. A direct action may be brought for a breach of a fiduciary duty owed to the shareholder by an officer or director. To distinguish breaches of duty owed to the corporation and duties owed to the shareholder, ask 1, who suffers the most immediate or direct damage, the corporation or the shareholder, and 2, to whom did the defendant's duty run, the corporation or the shareholder. In a shareholder direct action, any recovery is for the benefit of the individual shareholder. Recovery to corporation. In a derivative action, the shareholder is asserting a corporation's rights rather than her own rights. So if a shareholder's plaintiff wins a derivative suit, who gets the money from the judgment? The corporation. Remember, it's the corporation's claim being brought by the shareholder. Court may order payment of expenses. The shareholder plaintiff may recover costs and attorney's fees, usually from the judgment won for the corporation. After all, the shareholder did favor to the corporation by suing and winning. If the shareholder plaintiff loses the derivative suit, they cannot recover costs and attorney's fees. If the court finds that the action was commenced or maintained without reasonable cause or for an improper purpose, it may order the plaintiff to pay reasonable expenses to the defendant. So the shareholder may be liable to the defendant they sued for that defendant's attorney's fees if they sued without reasonable cause. Requirements for derivative suit. Standing. Stock ownership at time of wrong and throughout the suit. To commence and maintain a derivative proceeding, the shareholder must have been a shareholder at the time the claim arose and must have become a shareholder through transfer by operation of law from someone who did own stock at the time the claim arose. Examples of transfer by operation of law include getting stock through inheritance or by divorce decree. Adequate representation. A shareholder must also fairly and adequately represent the corporation's interest. Demand requirements. Under the N as in Mary, B as in boy, C as in cat, A, and BCA, the shareholder must make a written demand on the corporation. Usually that means the board to take suitable action. In some states, this demand must always be made, and the shareholder cannot sue until 90 days after making this demand. In such case, a derivative proceeding may not be commenced until 90 days have elapsed from the date of the demand, unless the shareholder has earlier been notified that the corporation has rejected the demand, or 2, irreparable injury to the corporation would result by waiting for 90 days to pass. In other states, shareholders are not required to make this demand if the demand would be futile. A good example of such a case is when the majority of the sitting directors would be the defendants in the suit. In other words, it's futile to make this demand when we're suing those very directors. So, next page. 54. Corporation joined as a defendant. The corporation must be joined to the suit as a defendant, even though the suit asserts the corporation's claim, since the corporation did not do so. It is joined as a defendant. Dismissal or settlement requires court approval. The parties can settle or dismiss a derivative suit only with court approval. The court may not give notice to shareholders to get their input on whether to settle or dismiss. After the derivative suit is filed, the corporation may move to dismiss. Dismiss if found not in corporation's best interest, investigation of independent directors or panel, court determination, and burden of proof. So those are the last 4 sections in this module. So in a derivative suit, after the demand, the corporation is joined as a defendant. And who's going to motion to dismiss? Probably the corporation. Yes, and they'll dismiss if found not in corporation's best interest. The dismissal must be based on an independent investigation that concluded that the suit is not in the corporation's best interest. For example, it has a low chance of success, or the expense of the case would exceed the recovery the corporation would win. Investigation by independent directors or panel. The investigation must be made by independent directors or a court-appointed panel of 1 or more independent persons. Usually, it is a special litigation committee of independent directors. Court determination. In ruling on a motion to dismiss, the court finds that 1, those recommending dismissal were truly independent, and 2, they made a reasonable investigation. In most states, the court will dismiss. In some states, the court will also make an independent assessment of whether dismissal is in the corporation's best interest. Burden of proof. To avoid dismissal in most cases, the shareholder bringing the suit as a burden of proving to the court that the decision was not made in good faith after reasonable inquiry. However, if a majority of the directors have a personal interest in the controversy, the corporation will have the burden of showing that the decision was made in good faith after reasonable inquiry. Module 8, shareholders voting. Who votes? General rule, record shareholder and record date. As a general rule, the record shareholder as of the record date may vote at the meeting. The record shareholder is the person shown as the owner in the corporate records. The record date is a voter eligibility cutoff date. It's fixed by the board of directors but may not be more than 70 days before the meeting. Directors don't set a record date. A record date is deemed to be the day of the notice of the meeting, that the meeting is mailed to the stockholders, unless the articles provide otherwise. Each outstanding share is entitled to one vote. Exceptions to the general rule. There are a few exceptions to the general rule that the record owner on the record date is who votes. Treasury stock. Suppose the corporation reacquires stock before the record date, so the corporation is the owner of the treasury stock. Does it make sense? No. So this is going to only be run on like outstanding and issued and outstanding shares. Authorized and outstanding. Issued and outstanding. Voting by proxy. A shareholder may vote their shares in person or by proxy executed in writing. A proxy is 1, a writing, fax, or email are fine. 2, signed by the record shareholder. Email is fine if the sender can be identified. 3, directed to the secretary of the corporation. 4, authorizing another to vote the shares. Revocation of proxy. A proxy is generally revocable by the shareholder and may be revoked by the shareholder. Attending the meeting to vote themselves in writing to the corporate secretary or by separate appointment of another proxy. A proxy will be irrevocable only if it states that it is irrevocable and is coupled with an interest or given as security. This requires 1, the proxy says it's irrevocable, and 2, the proxy holder has some interest in the shares other than voting. Statutory proxy control. The rules governing proxy solicitation provide that 1, there must be a full and fair disclosure of all material facts with regard to the management submitted proposal upon which the shareholders are to vote. 2, material misstatements, omissions, and fraud in connection with solicitation of proxies are prohibited. And 3, management must include certain shareholders' proposals or issues other than election of directors and allow proponents to explain their position. Shareholder voting trusts and voting agreements. Let's say X, Y, and Z own relatively few shares in C Corp. An exam question might ask you for your opinion as to how they may increase their influence by block voting, meaning voting alike. They may do so in a voting trust or a voting agreement. Requirements for voting trust. A voting trust is a written agreement by shareholders under which all of the shares owned by the parties to the agreement are transferred to a trustee who votes the shares and distributes the dividends in accordance with the provisions of the voting trust agreement. The trust is not valid for more than 10 years unless it is extended by the agreement of the parties. Note, this 10-year limit has been eliminated in most versions of the NBCA. The requirements are as follows on the next page: a written trust agreement controlling how the shares will be voted, a copy of the agreement, including names and addresses of the beneficial owners of the trust, is given to the corporation. Legal title to the shares is transferred to the voting trustee, and the original shareholders receive trust certificates and retain all shareholder rights except for voting. Requirements or voting agreement. Rather than creating a trust, shareholders can enter into voting or pooling agreements provided for how they'll vote their shares. The requirements are that agreement must be in writing and signed. It need not be filed with a corporation and is not subject to any time limit. States are split as to whether voting agreements are specifically enforceable. In states that will grant specific performance of a voting agreement, which increasingly they do, there is no need to use voting trust. So either a voting trust or a voting agreement can be used for any improper purpose. There's a 10-year maximum for a voting trust, but it's renewable. A voting agreement can be perpetual. And in a voting trust, legal ownership is transferred to the trustee. Shareholders retain beneficial ownership. Whereas in a voting agreement, shareholders retain both legal and beneficial ownership. Where do the shareholders vote? Convening meetings. Shareholders usually take action at a meeting, or they can act unanimous written consent signed by the holders of all voting shares. The meeting need not be held in the state of incorporation. There are two kinds of shareholder meetings, annual and special. The writing can be an email, by the way. I just skipped that for flow. Annual meetings. Corporations must hold annual shareholders meetings. If the annual meeting is not held within the earlier of 6 months after the end of the corporation's fiscal year, 15 months after its last annual meeting, the shareholder can petition the court to order one to be held. And what do shareholders do at the annual meeting? Primarily, they elect directors. Special meetings may be called by 1, the board of directors, 2, the president, 3, the holders of at least 10% of the outstanding shares, 4, anyone else authorized to do so by articles or bylaws. Notice shareholders must be notified of meetings not fewer than 10 or more than 60 days before the meeting. Notice must be in writing, fax or email is fine to every shareholder entitled to vote. Notice may be waived in writing or by attendance. Contents of the notice. The notice must state the date, time, and place of the meeting. For special meetings, the notice must also state the purpose of the meeting. Why is the statement of purpose important? The shareholders cannot do anything else at that meeting that is not listed in the purpose. Consequence of failure to give proper notice. If proper notice is not given to all shareholders, whatever action is taken in the meeting is voidable and may be void unless those who were not sent a notice waive the notice effect. How can such waiver occur? In either of two ways. Express waiver, meaning in writing and signed any time, fax or email are fine, or implied waiver, meaning the shareholders attend the meeting without objecting at the outset. 8.3, how do shareholders vote? Shareholders generally get to vote on these things: to elect directors, to remove directors, or on fundamental corporate changes. They may also vote on other things if the board asks for a shareholder vote on things. Quorum. Every time the shareholders vote, that we must have a quorum represented at the meeting. Termination of a quorum focuses on the number of shares represented, not the number of shareholders. The general rule is that a quorum is the majority of outstanding shares entitled to vote, unless the articles or bylaws require a greater number. Note that a shareholder quorum will not be lost if people leave the meeting, in contrast to a director's meeting. Voting in general, if a quorum requirement is met, the shareholders vote. Absent a contrary provision in the articles, each share is entitled to one vote. The articles may provide for weighted voting or contingent voting. If a quorum is present, generally shareholders will be deemed to have approved a matter if the votes cast in favor for the matter exceed the votes cast against the matter, unless the articles or bylaws require a greater proportion. Cumulative voting, optional. Cumulative voting usually comes up only in closed corporations. It gives smaller shareholders a better chance of electing someone to the board of directors. Note that this is available only when shareholders elect directors. Compare straight voting. Usually with straight voting, we have a separate election for each seat of the board being elected. Each outstanding vote gets one vote for each seat. The candidate who gets more votes than another is elected to the seat. Mechanics of cumulative voting. With cumulative voting, we don't vote for each seat individually. We have one at-large election. The top two, or however many finishers, are elected to the board. To determine your voting power, when cumulative voting exists, multiply the shareholder number of voting shares at the time of the number. I know that's not English. To determine your voting power when cumulative voting exists, multiply the shareholders' number of voting shares times the number of directors to be elected. The total number may be divided among the candidates in any manner that the shareholder desires, including casting all for the same candidate. Must be provided for in articles. Say the articles of C Corp are silent as to whether shareholders can vote cumulatively. Do the shareholders have cumulative voting rights? Generally, no. There is no cumulative voting right unless the articles provide for it. Class voting on article amendments. Whenever the amendment to the articles is incorporation will affect only a particular class of stock, that class has a right to vote on the action, even if the class otherwise does not have voting rights. Shareholder resolutions. As a general matter, shareholders are permitted to submit resolutions on proposals for action at shareholder meetings. For example, shareholders may express views on corporate matters through non-binding resolutions. Generally, shareholder resolutions seek to bind the corporation or the board should involve a proper subject for shareholder action, such as seeking an amendment to the bylaws. Stock transfer restrictions. One great thing about corporations is transferability of the ownership interest. A shareholder can sell or give their stock away. Sometimes people want to restrict transferability, especially in closed corporations, so they can keep stock out. For example, I'm not reading examples, but there's a first right of refusal in this example. Restrictions are fine if reasonable. Restrictions are valid if they are not an undue strain on alienation. The right of first refusal is valid. It does not restrict the ability to transfer, but only requires the shareholder to offer the stock first to the corporation. Now, a chart involving shareholder voting is on the page 63. I never like really reading these because it's another decision tree. And it doesn't quite come out right. So begin with, is there a quorum? If no, shareholder action generally is invalid absent unanimous written consent. If yes, does the shareholder action involve election of a director? If no, the shareholder action will be deemed approved if votes cast in favor of the action exceed the votes cast against the action. If the answer to that question was actually in the alternative yes, does the corporation have cumulative voting? If no, each shareholder gets one vote per share held to vote for each available position. The shareholder may not cast more than one vote per share held for any one position. Example, shareholder has 50 shares, 3 directors are being elected. Shareholder gets 50 votes to cast for position, 50 votes to cast for 2, and 50 votes to cast for position 3. That's not an or, that's a, okay. That's an and, so they get like 150 votes for their 50 shares. Shareholder can vote a maximum of 50 votes for any one candidate per one position. Each shareholder gets as many votes. Okay, so if your answer was yes, they do have cumulative voting. I'm going to go through that cumulative voting process. Whatever I just went through, I don't really know what that stands for. It's like one vote per share held for any one position. And then they said it again in case you didn't get it the first time. So for cumulative voting, each shareholder gets as many votes per share held as there are directors being elected. A shareholder may divide the votes among candidates in any manner or may cast all votes for any one candidate. The candidate getting the most votes wins. Shareholder has 50 shares. 3 directors are being elected. Shareholder gets 150 cumulative votes to cast. Shareholder can vote all 150 votes for one candidate for one position. So since that is like completely not, I'm just going to print that page. Because to me, it's not, God, the word. I'm looking for intuitive. It's so not intuitive to me how you vote. And I'm not sure if I'm really ever going to have to explain it. So I'm printing it out and putting it on the wall with any luck. So page 64, I can't believe we're still in this module. Enforcing restriction against transferee. If the restriction is reasonable and thus valid, it cannot be enforced against a transferee, a third-party purchaser, unless 1, the restriction is conspicuously noted on the stock certificate or is contained in the information statement required for uncertificated shares. Or 2, the transferee had actual knowledge of the restriction at the time of the purchase. Shareholders' inspection rights. A shareholder has a right, personally or by agent, to inspect and copy the books and records of the corporation. Standing. Generally, any shareholder can demand access. Procedure under the NBCA. The procedure followed depends on the material sought. Generally, for non-controversial things, shareholders have an unqualified right of access. For more controversial things, the right of access is disqualified. A. Unqualified right of certain records. Any shareholder may inspect the following records regardless of purpose. 1, the corporation's articles and bylaws, board resolutions regarding classification of shares, minutes of shareholders' meetings from the past 3 years, communications sent by the corporation to shareholders over the past 3 years. 5, a list of names and businesses addresses of the corporation's current directors and officers. And 6, a copy of the corporation's most recent annual report. The shareholder must make a written demand at least 5 business days in advance. Qualified right. For more controversial things, such as 1, excerpts of the minutes of board in contrast to shareholder referenced above meetings. 2, the corporation's books, papers, and accounting records. And 3, shareholder records. The shareholder must state a proper purpose for the demand. What's a proper purpose? It's one that's reasonably related to the person's interest as a shareholder. The shareholder also must provide 5 business days advance written notice. The shareholder may not personally conduct the inspection. They may send an attorney, accountant, or other agent. 8.5.3, failure to allow proper inspection. If the corporation fails to allow proper inspection, the shareholder can seek a court order. If they win, they can recover their costs and attorney's fees incurred in making the motion. Compare directors' inspection rights. Recall the directors need not go through this procedure to get access to corporate books and records. Directors have better access to such materials because they need access to discharge their duties. Distributions. These are payments by the corporation to shareholders. Types of distributions. They can take the form of dividends, repurchases of shares, meaning the voluntary sale of shareholder stock to the corporation, redemptions at a price set in articles, distribution of assets upon liquidation, and so on. Rights to distributions. At least one class of stock must have a right to receive the corporation's net assets on dissolution. Beyond this rule, distributions generally are discretionary. Declaration generally solely within the board's discretion. Even if the article authorized distributions, the decision whether to declare distributions generally is solely within the director's discretion, subject to solvency limitations below and any provisions to the contrary in the shareholders' agreement or the articles. A shareholder has a right to a dividend or other distribution only when the board declares it. Still in Module 8. The shareholders have no general right to compel a distribution. Because the decision about distribution is the board's, it is difficult to win a case to force the declaration of a distribution. An action to compel declaration of a distribution is direct, not derivative. To win, the plaintiff must make a strong showing of abuse of discretion. For example, maybe the corporation consistently makes profits and the board refuses to declare a dividend while paying themselves a bonus. Which shareholders get dividends? A record shareholder of the stock as of the record date will receive the dividend. Limitations and preferences. Shares may be divided into classes with varying rights. For example, some classes may be redeemable, others not. Some may have no right to receive distributions, while others have preferences, etc. Terminology. Preferred stock is paid before common stock is paid. The right to preferred dividend may or may not accumulate if unpaid in a particular year, that is cumulative versus non-cumulative preferred shares, or may accumulate only if there are sufficient current earnings, that is cumulative if earned preferred shares. Preferred shares have no right to the share of the distributions made on common shares unless the preferred shares provide they are participating. Rights after declaration, same as general creditor. Once a distribution is lawfully declared, the shareholders generally are treated as creditors of the corporation, and their claim for the distribution is equal in priority to claims of other unsecured creditors. However, a distribution can be enjoined or revoked if it was declared in violation of solvency limitations. The articles are a superior preference right. I'm totally skipping this one page long hypo, and we're still in module 8 on page 68, all of which I read today. All of the other 67 pages I read today. Limitations, restrictions in the articles. The articles may restrict the board's right to declare dividends. For example, a creditor might insist that the corporation includes articles of provision prohibiting payment of any distributions unless the corporation earns a certain amount of profits. Share dividends. Distributions of a corporation's own shares, that is, share dividends or stock dividends to its shareholders, are excluded from the definition of distribution. Therefore, the above restrictions are inapplicable. However, shares of one class or series may not be issued as a share dividend in respective shares of another class or series unless one of the following occurs. 1, the articles so authorize. 2, the majority of the votes entitled to be cast by the class or series to be issued approves the issue. And 3, there are no outstanding shares of the class or series to be issued. 8.6.3, which funds can be used for any distribution, meaning a dividend, a repurchase, a redemption, and so on. Which funds can be used? Traditional view, 3 funds. The traditional view requires us to talk about 3 funds: earned surplus, stated capital, and capital surplus. This is generated by issuing stock. How is capital surplus computed? Payment in excess of par plus amounts allocated in a no par issuance. Capital surplus can be used for distributions if you inform the shareholders. Remember that stated capital cannot be touched, but you can touch capital surplus if you tell the shareholders. So I'm gonna write this down. I just don't have anything to write with. That's impossible. Actually, it's kind of possible. When your board materials give you like calculations like this, like you must find something to write with and write it down. Please. All right, so over here, capital surplus. Payments in excess of par plus amounts allocated in a no par issuance. But we want to get rid of the term par. Plus what? Amounts allocated in a no par issuance. I don't even know what any of that means. This makes me think I don't even know what they're talking about. There's also an earned surplus and a stated capital. So I just wrote down capital surplus, earned surplus, earnings minus losses minus past distributions stated capital allocating the proceeds between the stated capital and the capital surplus can never be used for distributions. So this is generated by issuing stock, which is similar to capital surplus, which is discussed. And I discussed that one first. So when the corporation issues stock, it has to allocate the proceeds between the stated capital and capital surplus. Between the stated capital and the capital surplus. So those are your formulations. When you read capital surplus again, this is a payment exceeding par plus the payment amounts allocated in no par issuance. So this is like your entire capital, par plus amounts paid above it, whereas stated capital is some kind of difference between all of your capital and in the par account on your books, I think. So we were talking about in the last recording. So all of that is crazy. There's like 3 different methods that I wrote down from my from my case book. So we're just gonna keep on moving on. There's this modern view of insolvency, which is probably what I learned. The modern view doesn't look at funds that can be used for distributions. Under the modern view, the corporation cannot make a distribution if it's insolvent, or the distribution would render it insolvent. What that means is that distributions is not permitted if after giving it effect, either the corporation would not be able to pay its debts as they become due, or in the usual course of business, that is, the corporation is insolvent in the bankruptcy sense, in the corporation. So the other alternative is that the corporation's total assets will be less than the sum of its total liabilities, plus, unless the articles permit otherwise, the amount that would be needed if the corporation were to be dissolved at the time of the distribution to satisfy the preferential rights on dissolution of shareholders whose preferential rights are superior to those receiving distribution, that is, the corporation is insolvent in the balance sheet sense. So this is the 2 definitions of insolvency. Definition 1 mirrors bankruptcy. Definition 2 is, what did I just say? The balance sheet. It's really like assets minus liabilities minus like preferred shares is a negative number. Whereas this one, the bankruptcy, what that means is corporation not able to pay debts as they become due. All right, so this is dividend distribution kind of no-nos. All right, that's nice. What else are we gonna do now? Actually, I'm just gonna skip to page 70. Are we done with this yet? My God, liability for unlawful distributions, since that then follows. Directors are jointly and severally liable for improper distributions. A director who votes or assents to a distribution that violates the above rules is personally liable to the corporation for the amount of distribution that exceeds what could have been properly distributed. But remember, directors have a good faith reliance defense. The director is not liable for distributions approved in good faith. One, based on financial statements prepared according to reasonable accounting practices or on a fair valuation of or other method that is reasonable under the circumstances, or two, by relying on information from officers, employees, or legal counsel, accountants, etc., or a committee of the board of which the director is not a member. A director who is held liable for an unlawful distribution is entitled to contribution from one. Every other director who could be held liable for the distribution, that is, those who voted in favor of the distribution, and two, each shareholder for the amount she accepted while knowing that the distribution was impermissible. And the shareholder liability, shareholders are personally liable only if they knew the distribution was improper when they received it. Fundamental corporate changes is module 9. And I know, like, this is probably the most important section. There's a dissolution section, tender offers and corporate control problems, federal securities laws starts on page 83. And it's awful long. It goes to 91. So back to page, 71 or something that I'm on right now. Can I read 20 more pages? I'm just trying to think what I have to substitute this, because I just wrote down the federal laws that I need to know. And I know which fundamental corporate changes the shareholders need to vote on. So I'm about to just say that and get out of here. Based on my note card of fundamental changes that needs to be voted on by, let's just go through this. Procedure for fundamental corporate changes. Fundamental corporate changes are extraordinary, so the board generally cannot do them alone. Generally, to do any fundamental corporate change, we need one, board action, adopting a resolution of fundamental change. Two, the board submits the proposal to the shareholders with written notice, and three, shareholder approval. For most of these changes, we also need to deliver a document to the Secretary of State. Shareholder approval. The shareholder vote that's required to approve the fundamental corporate change follows the ordinary voting rule. At a meeting where a quorum is present, votes cast in favor exceed votes cast against, and there's a typo there. Under the traditional rule, in contrast, what's required is the majority of the share entitled to vote. Dissenting shareholders' right of appraisal. If the corporation approves certain fundamental corporate changes, the shareholders who did not vote in favor of the change may have appraisal rights. The dissenting shareholders' right of appraisal is the right of a shareholder to force a corporation to buy their stock for fair value. Applies only to certain fundamental changes. Only certain fundamental corporate changes will trigger the right of appraisal. Merging or consolidating, transfer of substantially all assets not in the ordinary course of business, or transfer of shares in a share exchange, converting to another form of business. Exists in closed corporations. Note that even if the company is doing one of these changes, there is no appraisal right if the company's stock is listed on a national exchange, that is, it is a publicly held corporation, or if the company has. So if it's not, No, if it is. But it needs to have 2,000 or more shareholders, not shares, shareholders, and the shares involved have a value of at least 20 million, exclusive of the shares held by any senior directors, directors or shareholders owning more than 10% of the shares. This is known as the market out exception. What it means is the right of appraisal exists in close corporations. This makes sense because if you don't like a fundamental change in a public corporation, you just sell your stock on the public market. But if in a closed corporation, there is no market to buy the stock, so you can force the company to buy your stock. Perfecting right of appraisal. For a shareholder to perfect the right of appraisal, there's 6 bullets here. If a proposed corporate action will create dissenters' rights, the notice of the shareholders' meeting at which a vote on the action will be taken must state that the shareholders will be entitled to exercise their dissenting rights. For the shareholders' vote, the shareholders must file with the corporation a written notice of objection and intent to demand payment. At the shareholder vote, the shareholder must abstain or vote against the proposed change. They cannot vote in favor of the proposed action. Fourth, if the action is approved, the corporation must notify within 10 days after approval all shareholders who filed an intent to demand payment. The notice must include the time and place to submit their shares and the other terms of the repurchase. Within the time set by the corporation, the shareholder must make written demand to be bought out and deposit their stock with the corporation, and the corporation must pay the dissenters the amount the corporation estimates as their fair value of shares plus accrued interest. So that's like 6 things you have to do in like a lot of words. So they need to basically put the shareholders on notice of their right to an appraisal at the shareholders meeting. Shareholders can't vote. They should put the company on notice who want to exercise their dissenters' right. And the dissenters must learn within 10 days after approval how to basically dissent to get paid out. And then they must make a written demand to be bought out, shareholders that is, at the value that the corporation estimates is proper. So those are those 6 points. Now, if the shareholder is dissatisfied with the corporation's determination of value, the shareholder has 30 days in which to send the corporation their own estimate of value and demand payment of that amount for the difference between her estimate and the amount sent by the corporation. If the shareholder and the corporation cannot agree on the fair value of the shares, the corporation must file an action in court within 60 days of receiving the shareholder's demand, requesting that the court determine the fair value of the shares, and the court may appoint an appraiser. If the corporation does not so file, the corporation must pay what the shareholder demanded. Exclusive remedy, absent fraud, the right of appraisal is the shareholder's exclusive remedy. They don't like a fundamental change. Amendments to articles of incorporation. The corporation, and again, they can exercise this for like a merger, a consolidation, transfer of substantially all assets, not in the ordinary course of business, assets of the company, and not in the ordinary course of business, obviously, and transfer of shares in a share exchange or converting to another form of business. So that's when they can elect their appraisal rights. Amendments to the Articles of Incorporation. A corporation can amend its articles by following the procedure we discussed above. Certain housekeeping amendments, for example, deleting the names of initial directors named in the articles, changing the number of authorized shares after a stock split, can be made without shareholder approval, but most require approval of the shareholders. Shareholder approval, hypo, delivery to Secretary of State. If approved, the amended articles must be delivered to the Secretary of State. Dissenting shareholders' rights of appraisal. Shareholders generally do not have dissenting rights of appraisal for an amendment. Note, for an amendment that effectuates a reverse stock split, shareholders do get appraisal rights, but that is a very technical point. Mergers and consolidations. A merger involves the blending of one or more corporations into another corporation. And the latter corporation survives while the merging corporation ceases to exist following the merger. For example, B Inc. merges into A Corp. Note that a domestic corporation can merge with a foreign corporation into a new domestic corporation, but only if the merger is permitted in the foreign corporation state of incorporation. A consolidation involves two corporations combining to form a new entity. For example, A Corp and B Inc. form C Corp. For both mergers and consolidations, board of director action by both corporations required, as well as a notice to the shareholders and shareholder approval generally by both corporations. The required vote is the same as with amending the articles, meaning votes cast in favor must exceed votes cast against at the meeting, and there was a quorum. If approved, the surviving corporation must deliver articles of a merger or consolidation to the Secretary of State. There is a right of appraisal generally for shareholders entitled to vote on the merger or consolidation, and also for shareholders of the subsidiary in a short form merger discussed below. No significant change to surviving corporation. Approval of so what I just read in mergers and consolidations, it looks like who votes on this? The board of directors, as well as shareholders and shareholders. I don't know. They all approve of both corporations. There you go. But if there's no significant change to the surviving corporation, approval of plan of merger or shareholders of the surviving corporation is not required if all the following conditions exist. 1, the articles of incorporation of the surviving corporation will not differ from the articles before the merger. 2, each shareholder of the survivor whose shares were outstanding immediately prior to the effective date of the merger will hold the same number of shares with identical preferences, limitations, and rights. And 3rd, the voting power of the shares issued as a result of the merger will comprise no more than 20% of the voting power of the shares of the surviving corporation that were outstanding immediately prior to the merger. Short form merger of subsidiary. No shareholder approval is required for a short form merger. With short form mergers, a parent corporation owning at least 90% of the outstanding shares of each class of a subsidiary corporation may merge subsidiary into itself without the approval of the shareholders or directors of the subsidiary. The parent must mail a copy of the plan of merger to each shareholder of the subsidiary. Effective merger or consolidation. The surviving corporation succeeds to all rights and liabilities of the constituents. This makes sense because the constituent corporation disappeared. So a creditor that is of that corporation can sue the survivor. This is known as successor liability. Transfer of all or substantially all assets and share exchange. Another fundamental corporate change involves the transfer, meaning sale, lease, exchange, or other disposition of all or substantially all the assets of a corporation not in the ordinary course of business. We can group this together with a similar fundamental corporate change, share exchange, which is when one company acquires all of the stock of another. We treat these alike because functionally they're the same idea. One company is taking the other over for either all of its assets or all of its stock. What constitutes substantially all the assets? Oh my God. Varies from state to state. A good rule of thumb is that it requires a transfer of at least 75% of the corporate's assets. Fundamental change. Corporate change for transferring corporation only. Both the transfer of all or substantially all assets and The share exchange of fundamentally corporate changes for the transferring corporation only, not for the buyer. So the corporation disposing of the property must follow the fundamental change procedure. Board election by both corporations is required, as well as notice to the selling company's shareholders. For transfer of substantially all assets, we need approval by the transferring company's shareholders only. For a share exchange, only the shareholders of the corporation whose shares will be acquired need approve the share exchange. It's not a fundamental change for the acquiring corporation. There are dissenting shareholder rights of appraisal for shareholders of the selling corporation, but not for shareholders of the buying corporation. For a share exchange, articles of exchange must be delivered to the Secretary of State. Usually there is no filing in a transfer of assets. Successor liability. For the sale of substantially all assets, we do not expect successor liability. Why? Because the selling corporation still exists, meaning creditors can sue it. So the company that buys assets is not liable for the death of the company that sold the assets unless the deal says otherwise. There's also an exception if the buyer is a mere continuation of the seller, that is, it has the same management, shareholders, and so on. Also, there will be successor liability if the court concludes that the deal was really disguised as a de facto merger. Dissolution of a corporation may be voluntary and involuntary by court order. Voluntary dissolution by incorporators or initial directors if shares have not been issued or business has not yet been commenced. A majority of incorporators or initial directors may dissolve the corporation by delivering articles of dissolution to the state. All corporate debts must be paid before dissolution, and if shares have been issued, any assets remaining after winding up must be distributed to the shareholders. Dissolution by corporate act. The corporation may dissolve the corporate act approved under the fundamental change procedure. This means that we need board of director action, shareholder approval. Votes cast in favor must exceed votes cast against at a meeting where there's a quorum, and we must file a notice of intent to dissolve with the Secretary of State. Effective dissolution. A corporation that has been dissolved continues its corporate existence to wind up, but is not allowed to carry on any business except as appropriate to wind up to liquidate its affairs. We also need to notify creditors so that they can make claims. Barring claims against a corporation, a claim can be asserted against a dissolved corporation, even if the claim does not arise until after dissolution, to the extent of the corporation's undistributed assets. If the assets have been distributed to the shareholder, a claim can be asserted against each shareholder for his pro rata share of the claim to the extent of the assets distributed to him. However, a corporation can cut short that time for bringing known claims by notifying claimants in writing of the dissolution and giving them a deadline of not less than 120 days in which to file their claim. The time for filing unknown claims can be limited to 3 years by publishing notice of the dissolution in the newspaper in the county where the corporation's known place of business is located. Revocation of involuntary dissolution. The corporation may revoke a voluntary dissolution by using the same procedure that was used to approve dissolution. Involuntary dissolution. Involuntary dissolution, also known as judicial dissolution, because as mentioned, it happens by court order. Different players can ask for this. Action by shareholders. Shareholders may petition for involuntary dissolution on any of the following grounds: director abuse, waste of assets, or misconduct, meaning, for example, the directors have acted or will act in a manner that is illegal, oppressive, or fraudulent, or corporate assets are being wasted, misapplied, or diverted for non-corporate purposes. The directors are deadlocked in the management of corporate affairs. The shareholders are unable to break the deadlock, and irreparable injury to the corporation is threatened, or corporate affairs cannot be conducted to the advantage of the shareholders because of the deadlock. Shareholders are deadlocked in voting power and have failed to elect one or more directors for a period that includes at least 2 consecutive annual meeting dates, or the corporation has abandoned its business and failed to dissolve within a reasonable time. That's your involuntary dissolution section. Election to purchase in lieu of dissolution. As an alternative to ordering involuntary dissolution, a court might order a buyout of the objecting shareholder. This might be especially likely in a closed corporation. This alternative involves the corporation or one or more shareholders electing to purchase the shares owned by the petitioning shareholder at their fair value. Action by creditors. Creditors may seek judicial dissolution if the corporation is insolvent, and 1, the creditor's claim has been reduced to judgment, execution of which has been returned unsatisfied, or 2, the corporation has admitted in writing that the creditor's claim is due and owing. Action by Attorney General. They may seek a judicial dissolution of the corporation on the ground that the corporation fraudulently obtains articles of incorporation or that the incorporation is exceeding or abusing its authority. Court supervision of voluntary dissolution. A court may dissolve a corporation in an action by the corporation to have its voluntary dissolution continued under court supervision. Administrative dissolution. The state may bring an action to administratively dissolve a corporation for reasons such as the failure to pay fees or penalties, failure to file an annual report, or failure to maintain a registered agent in the state. The state must serve the corporation with a written notice of the failure. If the corporation does not correct the grounds for dissolution or show that the grounds do not exist within 60 days of the service of notice, the state effectuates the dissolution by signing a certificate of dissolution. Corporation that is administratively dissolved may apply for reinstatement within 2 years after the effective date of dissolution. The application must state that the grounds for dissolution either did not exist or have been eliminated. Reinstatement relates back to the date of dissolution, and the corporation may resume carrying on business as if the dissolution had never occurred. Winding up. Dissolution is not the end of the corporation. It is the beginning of a process that will end the corporation's existence. The corporation continues to exist, though it can sue and be sued. It cannot start new business, but must wind up. Liquidate. Steps for winding up. The following steps must be taken to wind up the corporation. Given written notice to known creditors to publish notice or dissolution in the newspaper in the county of the principal piece of business. Gather all assets. Convert assets to cash, pay creditors, and distribute the remaining sums to the shareholders pro rata by share unless there's liquidation preference. Those are like a dividend preference. Conversion. Conversion involves one business entity changing its form to another business form, such as a corporation converting itself to an LLC. A procedure for undertaking this fundamental corporate change will sound familiar. We need board approval and notice of shareholders, as well as shareholder approval. We also need to deliver a document to the Secretary of State. For conversion, shareholders also have a dissenting right of appraisal. Section 9.7, tender offer and corporate control problems. Federal regulation, the Williams Act. The Federal Williams Act controls tender offers. That is, offers by a bidder will purchase shares from shareholders of a target corporation. Regulation of the bidder. If a bidder makes a tender offer, a widespread public offering to purchase a substantial percentage of the target's shares, and the offer will result in the bidder obtaining more than 5% of the class of securities of the target, the bidder must file a Schedule 14D containing extensive disclosure regarding the bidder's identity, source of funds, past dealings with the target, and plans concerning the target. The bidder's financial statements if the bidder is not an individual, and any arrangements made with persons in important positions at the target. Regulation of the offer. Under the Williams Act, a tender offer must be held open for at least 20 days and must be open to all members of the class of securities sought. Shareholders must be permitted to withdraw tendered shares while the offer remains open. If the offer is oversubscribed, then the bidder must purchase on a pro rata basis from among the shares deposited during the first 10 days of the offer. And if the offer price is increased, the higher price must be paid to all tendering shareholders. Regulation of the target. The management of the target must either, 1, give its shareholders a recommendation concerning the offer with a statement of reasons or 2, explain why it cannot make a recommendation. General anti-fraud provision. The Williams Act also prohibits any false or misleading statements or omissions in connection with the offer. Shareholders can sue for damages for any false statements. And the shareholder SEC may seek to enjoin any false statements. State regulation controls share acquisition statutes. State controls share acquisition statutes regulate takeovers by providing that it is designated stock ownership threshold is crossed. For example, a bidder purchases shares that give him more than 20% of a class of share. The shares also purchased will not have voting rights unless the holders of a majority of disinterested shares vote to grant voting rights in the acquired shares. Note that the state may have more than one threshold, for example, 20%, 33%, 50%, and crossing from one level of ownership to the next will trigger the statutes. Limitation on scope to be valid. Control share acquisition statutes must be limited to corporations or transactions having a significant connection to the regulating state. For example, limiting application to purchases where 1,000 shareholders or at least 10% of the outstanding shares are located in the state. So we're at Module 10, which is the federal securities law, and we're going to go over Rule 10b-5, and I'm absolutely... Okay, let's just read this, because this is what I would have read from my own notes, is just the definition. I'm not going to break down what each one of these elements mean. 10b-5 makes it illegal for any person to use any means of instrumentality or interstate commerce to employ any schemes to defraud, make an untrue statement of material fact, or omit a material fact, or engage in any practice that operates as a fraud in connection with the purchase or sale of any security. In other words, this rule prohibits fraud or misrepresentation or non-disclosure in connection with the purchase or sale of any security. I really like it in a different order. So, reading it again, it requires scienter. Any person, directly or indirectly, by use of any device, scheme, or artifice to defraud, make any, does it say untrue statement of material fact, or omit to state a material fact, or engage in any act, practice, or course of business that would operate as a fraudulent conduct in connection with the purchase, sale of a security, use, means, or instrumentality of interstate commerce, and there's reliance, causation, and damages. Those last four elements aren't required everywhere, which is interesting because it's an SEC law, so I would think they do apply everywhere. But I'm not going to... tips and tippers is something that I didn't discuss in this definition. So here, an insider passes along material information, inside information for a wrongful purpose. In other words, when the insider gives a tip of inside information to someone else who trades on the basis of the inside information, the tipper can be liable under 10b-5 if the tip was made for any improper purpose, for example, the exchange of money or kickback as a gift or as a reputational benefit or so on. The tippee can be held liable only if the tipper breached a duty and the tippee knew or should have known that the tipper was breaching the duty. An insider breaches a fiduciary duty of trust and confidence when they give a tip of inside information to a friend or relative. They do not need to receive any pecuniary interest or something of value in exchange to be held liable. The tippee acquires the tipper's fiduciary duty of trust and confidence. Possible defendants: any person may include a company that issues misleading press reference, a buyer or seller of securities who mispresents material information, a buyer or seller of securities who trades on material inside information. When there's a duty to disclose, again, this comes from a relationship of trust or confidence with shareholders of the corporation or tippers and tippers. Jeez. Well, that was scary. I'm just going to read material just because I need to know it. Substantial likelihood that a reasonable investor will consider it important in making their investment decision. Scienter damages. Now, 16B is another SEC regulation. It talks about short swings and it's aimed at speculation. I read somewhere it's strict liability, presuming a likelihood that of manipulation by insiders, a manipulation of price by insiders. So in the essay I just wrote, they gave the definition as 16B provides any insider profit owning 10% of outstanding shares from any purchase price or sale within 6-month period of what I'm saying is a corporate event like a merger. So let's just read this definition in case I totally caught that wrong. It provides for the recovery. So that's what it provides for recovery of. Profits gained by certain insiders from buying or selling a company's stock. It's only an entitlement when the type of company is publicly traded, there's greater than 200 shareholders, and they have more than 10 million in assets. So that's when it applies. What happens when it applies? It's recoverable. And there's some math. And then we talk about Sarbanes-Oxley, Peekaboo, set up in 2002, if I'm not mistaken. Yep. And corporate responsibility requires an audit committee. Corporate responsibility for financial reports requires attestations from the CEO, CFO about the financials, and if they're wrong, they have to be republished. Then the CEO, CFO can't have their bonuses and profits. They have to disgorge them because they messed up. Prohibition against insider trades during pension blackout periods. Directors and executive officers of 1934 Act companies may not purchase or sell the company stock during a period when the persons participating in the company's pension plan are not allowed to sell company stock. Prohibition against personal loans to executives. And there's a statute of limitations for fraud, 2 years after the discovery of the facts giving rise to the cause, or 5 years after the action accrued. So that's going to be the end of this. I know I shortchanged the most important section, but just go ahead backwards like 10 minutes and listen to it 5 times.